everyone. My name is Lisa Plenster. I'm the division manager for the clerk's office in the federal court clerk's office here in South Bend. I have the pleasure of introducing our next speakers. Before I do, I just want to give a couple of housekeeping details. Don't forget to fill out your blue CLE form, and you can drop it in the basket on your way out this afternoon. Really appreciate it. We appreciate your attendance. So everyone knows, when you go to exit the parking garage, if you exit on MLK Drive, the gate should be open, and you won't have to pay for your parking. I can't guarantee the same if you exit from the other side. So I have the distinct honor of introducing two former bosses of mine. Very lucky person to have worked for both of these gentlemen at one point or another. The Honorable John E. Broden, a native of South Bend, Indiana. John Broden was elected to the as judge of the St. Joseph Circuit Court in November of 2016 and re-elected to another 6-year term in November of 2022. Judge Broden was elected to the Indiana State Senate in 2000, served as the state senator for District 10 from 2000 to 2016. During his 16 years as a state senator, he served on the Judiciary, Environmental, Tax and Fiscal Policy, Appropriations, and State Budget Committees. Prior to his election to the Senate, he was a member of the South Bend Common Council and a law clerk to the Honorable Justice Roger O. DeGruler of the Indiana Supreme Court. He currently serves on the Model Civil Jury Instructions Committee as well as the Civil Bench Book for Judicial Officers Committee. He is a 1983 graduate of St. Joseph High School, a 1987 graduate of the University of Notre Dame, majoring in Government and International Affairs, and a 1990 graduate of the Indiana University Maurer School of Law in Bloomington. He's married to Josephine M. Manernowski, and they have 3 adult children. Not only is Judge Broden the most humble circuit court judge I've ever known.
He's the most humble circuit court judge any of us have ever known.
He may also be the most humble person I have ever had the pleasure to work for. So, let's see.
Damning phrase.
The Honorable Michael G. Gotsch Sr. I'll give you the shortened version. The Honorable Michael G. Gotsch Sr. is a United States Magistrate Judge in the United States District Court for the Northern District of Indiana. Previously, he served as the judge of the Circuit Court in Indiana's 60th Judicial Circuit from 2004 to 2016. Before becoming a judge, Judge Gotsch served as Chief Deputy Prosecuting Attorney and Chief of Staff in the Office of St. Joseph County Prosecuting Attorney. He began his legal career as a Deputy Prosecuting Attorney and Division Director in the Office of St. Joseph County Prosecuting Attorney from 1987 to 1998. Prior to commencing his legal career, he was a commissioned officer in the United States Army, rising to the rank of captain. He has received his undergraduate and law degrees from the University of Notre Dame. He was an adjunct assistant professor of law at the Notre Dame Law School for many years and has served as a moot court and mock trial judge. He is a regular lecturer at law schools, universities, and colleges, and continuing legal and judicial education conferences and seminars. He has been a keynote speaker and lecturer at national, regional, and state conferences and seminars. Please welcome Judges Gotsch and Broden.
Well, good afternoon, and thank you, Lisa, for that very kind introduction. And I'm glad you omitted the Winston Churchill quote. He is very modest, and he has much to be modest about. So anyway, as you can see, this is making the tax sale less taxing, and we will get underway. Topics for review. This is kind of an overview of the presentation, and we'll be going over types of tax sales. You can see the 2 kinds listed there, the tax sale process. I'll be focusing quite a bit on that. Judge Gotsch will be addressing the due process considerations, and then I'll come back and we'll share, I think, parts of the legal claims and proceedings, things sort of subsequent to the order, and also practical considerations. So we'll be addressing each of those. The two types of tax sales. There are two ways to become a tax sale purchaser or buyer. And we'll go over to, or we'll address sort of when and how the tax sale is set. That's done through a joint petition from the treasurer and auditor. But essentially the two types of sales are, there's the tax sale, some people call it the A sale, and then there's the commissioner's sale, which is, frankly, doesn't involve the courts, essentially at all. But the commissioner's sale, so-called C sale, comes after no one purchases, there's no bids at the A sale, which of course is where most of these properties are sold, if you will. And there's a note at the end, very important. The tax sale sells the lien on the property, which may be perfected into title. However, a tax sale lien does not automatically transfer title or possession of the property. Very important note. Tax sale overview. This is the county tax sale. And how does it start? So many of these things are going on outside of the purview of the court. This is being done in the auditor and the treasurer's office. The auditor keeping a list, the treasurer reporting to the auditor. For example, when, or I shouldn't say for example, when a property is delinquent, 18 months or 3 tax sale periods, spring or fall, spring, fall, it can find its way onto a list. I think, and then that list is maintained by the county auditor. But that's how the list is, the origins of it. And again, it doesn't involve any court process. That is until the county is ready to commence with the tax sale process, and we'll get into that shortly. In fact, some of these things I'll save for a little later. So this is the not less than 50 days after the tax bill due date, the county treasurer shall certify to the county auditor the list where property taxes or special assessments from the prior year's spring installment or before are delinquent. That is obviously not paid in full. The auditor maintains this list. After receiving the list, the auditor then publishes, mails certified mail notice. The statute does, of course, say certified mail, that it's eligible to be sold at a tax sale, and any also includes any mortgagee, of course, who has an interest in the property. The notice must be posted in the courthouse or public building. Oops. Okay, this is when sort of the court process starts. So we get a letter, typically well in advance. Mr. Heppenheimer has been handling these sales for a long, long time, and he advises when he will be filing the county's notice of tax sale, and it requires, of course, that we schedule a hearing. There's very specific timelines on these as to when the hearing must be held, and then when the court has to issue its order to allow the sale to proceed. If there's any errors in that, it can frankly muddle the tax sale before it even gets started. So there's very critical timelines there. And as you can see, not less than 3 days before the tax sale, the court enters judgment for those taxes, special assessments, penalties, and costs that appear to be due. The previous bullet point is also critically important, and that is not less than 7 days before the sale. And I think we typically do it between like 10 and 14 days. There's a hearing. It's always on our calendar. That hearing is always on our calendar. It's to, if anyone has filed an objection as to why their property should not be on this tax sale list, they can file a written objection and or appear at the hearing. Thus far in the 6 years, I guess, I've been doing the tax sales, we've never had anyone appear at the hearing, but again, statutorily required that we have the hearing, and again, we've typically done it in that 10 to 14 day window, and then if nobody appears at that hearing, if If there's no objection, or certainly nothing that would prevail, then the court issues its order, and typically just obviously outside that 3-day window, but in close proximity to it. Then you have the court judgment and order of sale, and those are the properties that are going to be offered at the tax sale, the county tax sale, and of course those properties may be removed from the list if the delinquent taxes, special assessments, penalties, interest and costs have been paid in full.
So I actually had several that came in and for the objection period, and they had various reasons why they thought the objection was legitimate. Sometimes it was, of course, a lot of times it was they had partially paid, but that isn't sufficient. They have to fully pay. So those properties would not have been removed then from the sale. But we had some that came in that were organized as a non-for-profit or a church, and they wanted to be removed from the sale for various reasons. And so you have to go through this objection process. If you make an order and say that those won't be removed from the tax sale, they can still come in then and pay the matter in full and get removed before that final order goes out. So that's why this timing is important. Sorry.
No, appreciate it. And it is advantageous financially to do it then, because we'll get into a little later, there's an additional cost if you redeem in windows after the order. Okay, the tax sale must be held at, St. Joe County has traditionally seemingly held their tax sale in the fall. It seems like it's in September. Obviously, just to make sure your list isn't stale, if you will, the sale has to be held within 170 days after that list is certified to the auditor. Real property may not be sold to collect delinquent personal property taxes or taxes or special assessments which apply to other properties. It can only be with respect to the subject property that is on the list. And there again, real property may not be sold if indeed the taxes and assessments and costs have been paid prior to the tax sale, which again is typically in September. Let's see, real property may not be sold at the county tax sale for less than the amounts are listed there. Delinquent taxes, of course, any special assessments. Let's see, all penalties due on the delinquencies, any unpaid costs from prior tax sale. There's your publication costs and any reasonable costs, including title search expenses, reasonable attorney's fees. Those are included.
And I assume your policy is the same. Normally we set a fee schedule when we issue the order ahead of time.
Yes, yes.
So there's a reasonable fee order set in advance so that there's no question about what a reasonable attorney fee would be and what other costs the county are entitled to collect.
Thank you. Purchaser must immediately pay the bid to the treasurer. This is like cash. I mean, this is in some respects very similar to where if you just go to the regular mortgage foreclosure sales, which used to be Thursday at 10 a.m. or whatever, you make your bid. Similar to a tax sale, you've got a, it has to be whether it's certified funds, cash, whatever it is, and immediately is what's stated. Obviously, you don't know exactly what you're going to get the property for. There could be other bidders, et cetera, but nonetheless, you have to be able to produce those certified funds, what we refer to as immediately, which certainly means in exceptionally close proximity to that sale. This goes on as to how the treasurer would apply the monies that come in on the tax sale purchases, the order of priority. Oops. Okay, any person may redeem the real property sold, meaning it doesn't just have to be the purchaser. It could be someone who, quote unquote, has a substantial interest in the property. Certainly can be a friend or relative or whatever, but in any event, anyone can pay the amount that's due. Now, we talked earlier about the timing. There's obviously, if it's offered or redeemed within 6 months of the tax sale, there's the 110% of the minimum bid. So there's some, some enhancement there. Then 115% if it's more than 6 months but less than 1 year into the redemption period. And all taxes, special assessment upon the property, plus the 10%, and then as Judge Gotsch referenced, the fees that are permitted pursuant to the schedule approved by the court. Now this is when the court gets involved, if you will. That is, if no one has redeemed the property, you'll note it says less than 61 days. Well, what that refers to is after 30 days, the court is going to review the petition for deed. And we've kind of gone in reverse order, so I want to be duplicative, but at this point there's been a critical, and I know we have a slide on it, and that is the 4.5 notices. Very critical. The 4.5 notices go out 6 months, or within 6 months of the sale. It used to be 9 months at one time. Now the General Assembly has changed it to 6 months. So your petition for deed is going to include that you've sent within 6 months of the sale to the purchaser and anyone, or excuse me, to the owner and anyone with a substantial interest in the property, which is why the title search is so important, because you have to demonstrate that you have indeed noticed through certified mail those 4.5 notices. But that's what, and I've been very blessed, I should interject, very blessed the entire time I've been doing the tax sales as circuit court judge. Outstanding staff. Lisa Plentzner was doing it my first several years, knew the tax sale process inside and out, knew exactly what to look for in the petitions. By the time they quote unquote hit my queue, which is now judge lingo now for when I see it in terms of an action. And then Emily Stuke, our current court administrator, was doing it for me as well. That is monitoring those things before they even hit the judge's queue to see if there's any red flags and certainly alert the court to things that may not be there. Carrie Tanner has been doing it for the last at least 1 year plus. I think this is our second tax sale go-round now we're receiving petitions on. But that's what we're going to be looking for. This is when the court, other than the process I referenced earlier where the county petitions for the sale has the list and we have that hearing, which again, in my tenure there hasn't been any objections. But this is a stage where the court is more involved in the tax sale process. The previous portions are administrative, if you will. So we're going to be looking at those 4.5 notices. Need to know that there's been a title search done. Need to know that they were sent certified mail. People typically scan those things in. So we check that very rigorously. That's critical before you can get an order for issuance of deed. And the 61 days, as I refer to it, is you have 30 days for anyone to object to your petition for issuance of deed. So I'm not going to sign any order until 30 days has lapsed. We're going to tickle that, if you will, and see that there is indeed no objection filed, and then within that next 30 days, if everything looks appropriate, the court would enter the order. Okay, the county commissioner's certificate sale. I mean, I view this one as pretty brief, if you will. I mean, if you can get a property at the commissioner's sale, you know, you're getting it free and clear of pretty much everything. I mean, we've got the list of things that survive, obviously things like liens that were there in advance, those type of things, but the certificate sale, the commissioner's sale, is really those properties that didn't sell at the tax sale. So it's another level. And I guess just a little bit of history. They started around 2007. I was in the General Assembly then, so I very much recall. I don't know if there were other persons interested, but the people who were most interested from a General Assembly standpoint in terms of testimony and such was mayors. The mayor of South Bend, Mayor Lickey, then came down, Mayor of Fort Wayne, Mayor of Indianapolis, Mayor of Evansville. They were very united that we've got too many, whether they would use the word zombie properties, properties that just, you know, it's not good when we, when a council member or mayor has to say, I'm sorry, this delinquent property that you've been hoping would be purchased at tax sale, nobody bid. Nobody wants to hear some convoluted reason as to why this property is not being rehabilitated, why it's sitting in this status. No one even wanted to pay whatever bare minimum of taxes and special assessments there were on it. So the commissioner's sale was created essentially because it even dispenses with those costs. And so, so it's yet another opportunity to get property back onto the tax rolls and off the delinquent, vacant, substandard, dilapidated. So that's my view of the commissioner's sale. A buyer of lien at a commissioner's certificate sale or issued a tax sale certificate with the same requirements as property purchased at county tax sale. The significant difference between the certificate sale and the so-called A sale is that the certificate sale has a briefer redemption period, 120 days. It's not the 1-year redemption period. It's 120 days. Again, at this point, it's an expedited process. Let's get these properties on the tax roll, get them out of the system, and so it's a much, it's reduced by a full 8 months, and the minimum bids, as we indicated, are reduced as well. Let's see. Tax deed vesting, granting, and absolute, and fee simple, absolute, free and clear of all liens and encumbrances created before or after tax sale, except those that have been granted priority under federal law and liens of state or political subdivisions. Prior easements remain. We said that of course makes sense. Tax deed does not extinguish easement recorded prior to the tax sale, and the tax deed conveys title subject to all easements recorded prior to the sale. Yes?
You may want to point out that one of the big things that people run across in these tax sales is that the tax deed does not extinguish code enforcement or creditors. And that's a typical thing that comes up quite a bit. So I just want to make that point that, they talk about that, but those code enforcement judgments do not get extinguished.
So if everybody heard that, so code enforcement judgments do not get extinguished, and the reason for that is that that's back to, if we go back to...
Liens of political subdivision.
Yeah, it's a lien of a political subdivision. It's in slide 17. By the way, we'll hand out the PowerPoint presentation at the end. We've got copies, I think, enough for everybody, but you'll get those at the end. But anyway, so on slide 17, basically says that liens under a political subdivision is not extinguished, so that would be code enforcement, for example. So this gets to be a big issue oftentimes because there's big code enforcement numbers. Yes, sir?
Regarding that, does the time start from the time restart from the time they get it to bring the property back?
That's negotiable, I think. In other words, if you've got the lien from code enforcement, oftentimes code enforcement wants to move forward. But if you're a tax sale purchaser and you show good faith efforts to fix the property, code will back off normally. That's been our experience. They'll work with you.
Then before I hand it over to Judge Gotsch, just a couple of what I would kind of call forest from the trees things based on the experience that I've had thus far. If you take on tax sale purchaser clients, this is, I mean, it's all statutory. I mean, it's all there in the code. There's definitely been some cases, don't get me wrong, there is some cases interpreting the statute, but these deadlines, maybe every county does a little different. I'm not certain about that, but St. Joseph County, I think I can speak for the jurisprudence of Judge Gotsch, certainly, and also the jurisprudence of Judge Crone. That is, these deadlines are by the legislature, and they're not may, they're shall. There's not a lot of leeway around these. So when you've got to send your 4.5 notices out, it's got to be certified mail. It's got to be within 6 months. It's not as though, knew or should have known. It's these are strict timelines. Everything is on a timeline, and so I was a practitioner for years, had a lot of things going, juggling a lot of things. But these are the type of cases that if you take, just immediately set up calendaring system, reminders. Don't miss those deadlines. Don't blow those deadlines, because there's really not a way around those. And the notice and the title search. I mean, if you do those fundamental things right, these tax sales can be pretty easy. Just got to think on due process, I think.
Well, yeah. So
are we?
Yes, we are.
Okay.
And our due process here is kind of a broad due process. So we're talking about both the way the legislature has set up the notice requirements, and then we'll talk a little bit more about constitutional issues as we go forward as well. So just to review, there are statutory notices that are due here, and it's threefold. So the county auditor issues this notice of tax sale by certified mail, the last known address, and if certified mail return receipt comes back, then they can serve by secondary means. Then there's the buyer notice of right to redemption that's sent to the property owner or a person with substantial interest. We've talked about that before a little bit. The 4.5 notice, we'll go into that in more detail here in a moment. And then finally, the buyer's notice of filing a petition for tax deed. The third notice, and that's what we call a 4.6 notice. That's they're getting ready. It's kind of like the Ali income free at the end. You've gone through the whole process. You're about to petition for deed, but you give them one last chance to do something about it. If there's something irregular, there's something improper, they can make some kind of a last minute filing and attempt to resolve that issue. And then we have a note here about the tax deed may be defeated if the 3 required notices were not issued in compliance with the legal requirements. This has happened. And oftentimes what happens is the property fails to go through the process, so the lien is not perfected, and so you can't take a tax deed, and the property then falls back into the next tax sale, is what happens. And so all the effort that you made and all the expenses you had are lost because you didn't perfect it and get a tax deed out of this process. So we're talking about each of the notices. So the first one obviously is the county auditor's notice. Is up here. Oop, did I skip? No, I guess not. Oh, county auditors, there you go. Okay. So the county auditor notice includes the list of tracts of real property eligible for sale at public auction, subject to redemption. It's going to have the key number and address and/or a common description, a minimum bid amount, and the cost to redeem that property. The auditor's notice must contain the location in some description, normally by a key number here and street address or some other common description. We don't usually have problems with the key numbers. Sometimes a property might not. It might be a vacant tract of land, and so it doesn't have a mailing address, so it would be then some type of a common description. And there's some case law, just because there's a misstatement in the key number does not necessarily invalidate an otherwise valid sale. The auditor's notice must include the owner's name, the name of a single owner, or a name of at least one of the owners. If there are multiple owners, must also have a statement of the procedure to be followed for a judgment and an order of the tax sale. So that's the auditor's notice. Then we get into the tax sale purchaser notice, the 4.5 notice. The 4.5 notice must be sent within 6 months of the purchase, either at the tax sale or certificate sale. It has to be sent by certified mail to the owner of record shown at the auditor's office and all other persons with a substantial interest shown by public record. Now, we mentioned before mortgagees. Mortgagees are required, if they have an interest in the property and they want it to be asserted, they need to file a notice with the auditor, and then the auditor knows that that mortgagee is interested in that property and wants to get notice. But if the mortgagee does not file that notice, then the auditor is under no obligation to search its records, search the recorder's records to determine who's got a mortgage on the property. It's up to the mortgagee to take some affirmative action here. So more about the 4.5 notice, and this is what I have a checklist kind of up here, because this is what the court checks when it gets to be time to issue the tax deed. Did the 4.5 notice include all of these items? So it has, and I'm not going to read all these to you, but you can see then here what is required to be included in the notice, the 4.5 notice. And so this is what the court is going to look at to make sure that this was done properly. Then on to the 4.6 notice. So this is the third and final notice. After 1 year, the redemption period expires. The purchaser can then petition the court for a tax deed and give notice, kind of the one last notice, as I described at the LELE income free notice. the 4.6 notice. So the contents of that here are that you have to give the same notice to the individuals that have the same interest under the section 4.5, and the notice is sufficient if it's sent to the address required under 4.5D of the chapter. And if the notice is given by publication, only one publication is required. So let's talk a little bit about our constitutional due process issues. So to meet the 14th Amendment of the U.S. Constitution, notice must be reasonably calculated to inform interested parties. That's the Mullane case from 1950, Mullane versus Central Hanover Bank. And reasonable calculation has been described as requiring a balancing of the government and individual interest sought to be protected. Due process may require additional reasonable efforts to provide notice when the person is aware that the original notice was ineffective. So if the mail comes back and you don't think they got it, you need to take some additional effort. Now, what I put up here actually was, and it got cut off a little bit because originally it was a posted notice, but this was actually a sign that was posted on a property. I think this is out in Oregon or some other western county. But in any case, the same thing's true here. One of the things you can do in addition to, as far as reasonable efforts, is to post a notice on the property. You don't have to do that, but if you want to protect yourself. And I know that when we did this presentation before, Stephen Esslinger was one of our speakers, and he talked about how he goes out and posts notice, and often we'll take a picture of that notice with a newspaper of the day, show the date, time that the notice was posted on the property. Is that overkill? Well, it isn't overkill if you get into what we're going to talk about later, which is when people attack the tax sale. So, there may be good reason to go out and to take some additional steps to protect yourself. And so the Mullane was the overall notice case. Flowers is actually a tax sale case from another state. And Flowers has been adopted, as you'll see here in a moment, by Indiana. So additional reasonable efforts would be noticed by regular mail, posting notice on the property door, or posting a sign on a vacant parcel of property, right? Because there's going to be no door to post on a vacant parcel. But if somebody is an owner, they would be under some obligation to check their property, and they see a sign sitting out in the middle of their property, they're going to wonder why that's there. So those are all ways to deal with due process issues. Then on to how Indiana has interpreted this. So the flower standard applies to tax sale cases in Indiana. That's the Neese case. Actually Neese was an opinion by Judge Crone. Due process demands a diligent search before attempting notice by publication. The LD case, so they published, this is an adoption case, but it's relevant here because they published notice in a newspaper of general circulation, but it was generally circulated in the African American community in Indianapolis. So the white grandparents didn't get notice of the adoption, and then when they went in to attack the adoption that had gone through, the court granted it because notice had not been reasonably calculated to get to them, because it wasn't in a publication that was likely that they would likely read, was what the court determined. Due process is met by the auditor in additional ways. In the Saw Creek case, that explains that. XL Investment Properties, a case out of LaPorte County. I don't know what the other counties do as far as their tax sale, but I know LaPorte County's models ours very closely, and I know that because Judge Stallbring came over and stole all of our documents before he set up his tax sale. So I know that theirs looks just like ours. I can't speak to any other county. But in that case, in XL, simultaneously mailed certified and regular notice was sent out, and then a subsequent published notice was sent out, and that was determined to be adequate under the circumstances. And then finally, a most recent case this year, certified and first-class notices met the constitutional due process requirement in the Savvy LLC case that just came down in October. Yes, sir.
thing that I wanted to have you address, if you go back to that slide you just had.
Sure.
A lot of people for 4.5 notices and probably 4.6 notices just publish in a newspaper. They may or may not do certified mail, or the certified mail comes back and they don't do the follow-up on the regular mail. Can you address?
Sure. So the question was, a lot of people just publish in the newspaper, and they don't bother with any of the other notices that we've described. I would worry about that. I would be concerned. Now I'm not deciding these anymore, but if I had been deciding them, I would be concerned about a published notice. I think that's why I included that adoption of LD case in there, because I think the point was there are better ways to get notice out. Now, we're on the cusp of what's going to happen next. Like, is email now going to be required? Who knows? They haven't gotten there, but I can imagine that's coming, right? So if I give you an email address at the auditor's office and I want to be emailed, will the courts require email to be sent out in lieu of some type of other notice? And if the email gets bounced back, what does that mean? But again, I think you go back to the Mullane case. Mullane resulted in it was an eviction case, as I remember. But basically, they didn't give the notice that was reasonably calculated under the circumstances to give actual notice. They said you could have posted a notice on the door of the apartment. You could have done other things here, and you didn't do them. So this was not notice reasonably calculated to advise the tenant that there was this issue going on. And I think the same thing is true. I think if you're just publishing, you're running a risk that it's not going to be found in the long run to be valid.
And you and I had this conversation. There's a footnote in Flowers.
Yes, footnote in Flowers.
About notice of publication is not.
It's the last refuge for the weak, right? So it didn't say that, but that's the point. The point is that if you're relying on publication, make sure your E&O insurance is paid up. It's really what if we're going to cut to the chase, so make sure your malpractice insurance is current, because I wouldn't do it that way. Okay, legal claims. Back to Judge Broden. We like the fighting
That is good.
lawyers here.
Thank you, Judge Gotsch. And a couple of practitioners' notes as we get into legal claims. The TS case, when the county does the petition to create the tax sale, that gets a TS cause number, obviously tax sale. Since January of 2017, when you are the tax sale purchaser and you're filing a petition for issuance of deed, you need to ask the clerk for a TP cause number. We used to have some semblance of chaos when all the post order claims were all filed in the TS. You would be trying to sort out what exactly was set for hearing today. Quite frankly, it was quite chaotic. Well, starting January of 2017, there was created this designation TP, presumably tax purchaser or whatever, and it's free. There's no charge, so it's not as though we're trying to gin up a way to create more court fees. There's no charge to get a TP cause number. So you file your petition for issuance of deed with the TP cause number. Now, let's say, so there, as we started out here, I think we talked about these earlier, there of course are ways to redeem the property even before it gets on the list. There's the 1 year period of statutory redemption. In that first window, 0 to 6 months, you do have to pay the 110%. 6 to 12 months, 115%, but nonetheless, you can prevent someone from getting a deed or the court not granting the deed if the taxes are paid prior to that. And then, which of course is referenced, you're going to receive the 4.5 notice within that 6 months. So if you, as the owner of the property or having a substantial interest, want to redeem, again, if you do it prior to that 6 months, you can save a little money there. Now, the not later than 30 days after the petition for deed is filed. So this is your 4.6 notice. So the tax sale purchaser, either pro se, self-represented, or through their counsel, is going to send essentially to the same people that were sending the 4.5 notice, but just yet another opportunity. So you're going to have that 30-day window to object, saying either, hey, they miscalculated the taxes, this shouldn't have been on here, I just found out about this because the letter went here. Well, that's not where the letter should have gone. There's ways to attack the 4.5 notice. And so there is that 30-day window between that period where someone files a petition for issuance of deed and the court just waits. Again, I'm just going to wait. I'm not going to take any action, at least for 30 days, so we'll see if there's any objections filed. If there are objections, they shall be set for hearing. It's not a may. We will set it for hearing, and the statute says we shall set it for hearing. The most common way to attack is sort of that second bullet point, whether it's 60B1, whether it's 60B6, 60B8, some type of trial rule 60B motion would presumably get this matter in front of the court for argument. I mean, some examples we've had one where the 4.5 notice sent sort of had the wrong amount of taxes that were due. It misstated the taxes. The amount of taxes due, maybe it was a cut and paste error, but nonetheless, it's sort of when the owner would have received this, it was sort of a much more daunting amount than what was actually owed. So that notice was flawed. So that was grounds to set that aside. So you have to have some reason. Judge Gotsch went through how the notice might have been deficient. So those issues can all be raised in the 60B motion, and again, they will be set for hearing. Let's see, I think we're on, let me go one more slide here. Let's see.
It's your surplus.
Surplus, yes. Surplus, very important thing to know about the tax sale surplus. First, there's a 3-year statute of limitations, 3 years from the date of the tax sale. If you don't file your petition for surplus, maybe you represent an heir, maybe somehow you have some type of standing to seek this surplus. And again, not to be redundant, but it's not like you can come in 4 years later and say, well, Judge, here's why I didn't find out about it in that 3-year window. The statute is ironclad. It's 3 years from the date of the tax sale. We always set these for hearing. Frankly, we always set these for hearing for 2 reasons. One, we want to make sure that you've noticed the right people on the petition for surplus. For example, we just had one recently where there was a dissolution proceeding. Certainly sounded like on its face that the petitioner wife had a very strong claim for the tax sale surplus, but the ex-husband hadn't even been noticed. So of course we just reset the hearing. We say, hey, notice this person. There's often these involve like other heirs and such, where one heir is, maybe more aware of what's going on. But again, we set these for hearing for 2 reasons. One, to make sure people know about them and that we can hear those objections then. And then 2, the amount. Sometimes Mr. Heppenheimer, who we always notice on these, will say, well, Judge, they have the amount wrong in the order. Since they filed their petition, the spring taxes were due and those were paid. So the surplus was $18,111. Now it's $16,000. So we always want to make sure the amount is correct. And then the other type of post-judgment hearing we see sometimes, and anybody familiar with the movie, Mr. Von Deck, yes.
I'm sorry, I just had a quick question on
Yes.
the petition for tax surplus. Is that in the TS case, TP case?
Ooh, excellent question, Mr. Von Deck. I would say that it typically has a TP cause number, but we wouldn't not hear it because it was filed in the TS. But there should be a TP because there should have been a deed that's gone out and such. So yes, should be a TP.
So then the only other question I have is just kind of logistically, how do you find the TP case that relates to the property? Because you'll have a client who comes in and says, this is the property, but they didn't get a notice, say, the 4.6 notice, so you don't know what the cause number is.
No, that's an excellent question, Mr. Von Deck. And in fact, that is certainly if you're having trouble with that, which you very well could. You're right. When you say how, I mean, you could try to search by name, you could search by interested party. There's certain things you could do to try to find the party in the TP cause number. But you're right. Ultimately, if you can't, just file it in the TS case, just to get it, you know, just so you don't, I mean, certainly, I can't imagine any judge sort of saying, hey, your petition's not timely because you filed it in the TS versus
Well, I know
the
I've
TP.
searching in my case, the issue I think is, isn't it like in re the petition protects it's not, you know, party versus party.
Right.
Yeah, that's probably a very good point,
Trying
Mr.
to-
Project.
So
Search-
that's where you know that notice that
Yeah.
that they always require you to file beginning. Are there any other related cases? That's where that's supposed to be included for that reason, so that the clerk can cross-reference
Yeah.
related cases, but that doesn't always happen. But that's why that exists in that, you know, the original notice that you file when you're filing the case.
Mitch, does your office track that?
What was the first question? though?
How do you find
Well, no, that's the second question. What was the first question?
Well, on the petition for tax surplus, is that filed
For
in
the surplus, that goes in the TP.
In the TP,
It
okay.
has to go in the TP
Gotcha.
because the surplus doesn't come into being until there's a deed issue.
Right.
Right? So it's going to, the request for surplus has to go through the TP.
Heath,
The finding of the TP cause number, it's an interesting question. The clerk should know it. A lot of times, you may want to call the tax sale supervisor in the auditor's office. Her name is Marella Carmela, C-A-R-M-E-N-A, Marella. Can't remember her extension number. I should know it. I know it. Call it 10 times a day. But they may have that TP number. But certainly, the surplus request has to go through the TP. Do not file a TS.
but don't, you know, not file anything. It's strongly preferred that it be.
Well, what happened is end up getting transferred out of the TS case.
That's right. What'll happen is,
So it's-
they'll file it, you file TS, one of these two ladies will call me, and I say, put it in the TP. That's what'll happen.
It has to get transferred because
See
it's,
what we put up with.
He doesn't.
And do-
There are parties in the TP though, Mr. Von. I
Oh, there
have
are.
a sample.
Okay,
For
okay,
example,
gotcha,
here's the
gotcha.
TP. You're right. It does say in the matter of the 2022 tax sale, but Kristen Bowe, petitioner, versus Marvin H. Rowe
Gotcha.
et al.
Okay.
So the TP should have who the tax sale purchaser is, whether it's Savvy Inn, as their name's been on there, they're a frequent purchaser. But you can at least try to search by, you know, party name in a
Yeah.
TP case.
Yeah.
so if you think about it, the TS case, of course, is the case that starts the whole mess. But then anything that happens post-tax deed really should be a TP case now. It's like a proceeding supplemental in the tax sale case.
Very good analogy.
For
Last- oh, sorry. I have my last one.
Yeah.
Anyone fans of the movie Breaking Away? Okay,
Sure.
we have a few hands go up. Okay, there is a
Little
post-judgment one we get, and that is refund. Sometimes Mr. Heppenheimer, maybe a parcel has been put on the tax sale list where the legal description was wrong. Maybe it shouldn't have been on the tax sale list. Tax sale purchaser buys it on, you know, what the heck, no one else is buying it. It's only $28. What can go wrong? Well, if the county files a petition to void the tax sale, and they meet certain parameters, the court will grant it, void the tax sale. You as the tax sale purchaser get your purchase price back, plus 5% interest per annum, and then your so-called 137 cost, as Judge Gotsch alluded to earlier. That is an attorney's fee scale, title search scale. So you get everything back plus 5%. But that's the refund section.
That's a country song played in reverse. You get your dog back, you get your truck back, you get your girl back. Yeah, right. Exactly. All right, anyways, moving on. So practical issues. I like this one because it's several Boy Scouts trying to lash together a tower, so it reminds me of my days in scouting. So practical issues. I'm not going to read through all these. I'm just going to touch on them. So if you get a property at tax sale, it's like anything else. You have to do a sales disclosure form. Once you have it, you don't have to pay the fee because you got it at tax sale, but you do need to. You're compulsorily required to file a sales disclosure form with the auditor's office. Why should you do a title search? Because you want to do due diligence on this property before you make a bigger mess than you have already. So make sure that you do that, because it's going to tell you who has current ownership and any bankruptcies involved. You know, again, there's danger there, Sherry. You know, if you got a bankruptcy issue, wow, that's probably not one you want to bid on necessarily. It gives you legal description, other information. If you've looked at a title document, you know that everything important is in Schedule B. So, you know, fly spec what's in Schedule B to make sure you understand everything that's you know, involved. And if you have any questions, ask the title company to provide you with extra explanation about the Title B stuff. You know, what are the benefits of that? So you discover, are there mortgages, liens, assignments? Are there code enforcement liens on the property? All the things that we talked about that may not be extinguished at the tax sale will all show up in a title search. The other thing is, after you get the title to the property, and if you're actually wanting to convey it in some fashion, probably a good idea. In fact, I think the case law says file a quiet title action. You know, most title companies are unwilling to underwrite the property unless you've you know, done a quiet title. Now, sometimes I've had it, you know, in my experience, that, you know, well, the reason is they want another round of notices. They want to make sure the quiet title gives another round of notices to everybody to come out of the woodwork in case they're there. You know, the estate of, you know, Ruby Jones, you know, finally shows up, you know, 2 years after, 3 years after the fact, because you're trying to do the quiet title action. So the title underwriters like that. Sometimes they'll insure over it, but expect a significant premium if you're going to get that treatment. And so, that's where we're going here. So some underwriters are willing to insure out of the tax deed, but they're going to look at these factors, and they're listed here. Length of time, any open mortgages, is it vacant land, what kind of notice was provided. Again, that goes back to what we talked about before, not just giving publication notice. You know, if you've given 3 types of notice, you're more likely to get the underwriter to look favorably on your plea, and then any judgments that are outstanding on the property. So, well, guess what? We got this under the timetable. So we have time for questions. Oh, what happened to my son? Oh, there you go.
I just want to make one point. The notices 4.5 and 4.6 says presentation shows you got 6 months to do the 4.5, and then the 4.6 goes after the 1 year redemption period. That's for the A sale, as they call it. That's the original tax sale. That happens in August, September. The commissioner sale is typically in March, February or March. That redemption period is 120 days. And the time limits are significantly reduced as well. The 4.5 notice has to be issued within 90 days of the tax of the certificate sale. So usually in June. Is that right? So for a certificate sale, the 4.5 notice is in 90 days, and then the 4.6 notice is going to be in 120 days. And you do the 4.6 notice, and usually most practitioners do the 4.6 and the petition for deed at the same time. One other thing, the court orders now, and these young ladies are amazing, and both judges know that, and the lady sitting right there, Lisa, as well. They keep them and me and the county straight in everything we do. The order that the court issues, usually the court would like, when you file your petition for deed after the redemption period, most practitioners should file a form of order. Some file it with a petition for deed. I wait for 30 days and file thereafter. They have a wonderful tickler system that comes up, and it shows when that's supposed to come up. And if I haven't filed my form of order, I get a screaming message. But if you're a practitioner, file a form of deed. Make sure there's some statutory language. And it basically says that when you get the order of deed, you have a time period to go to the auditor's office with the original certificate of sale that you get when you buy the property. You have to pay all the taxes that are duly owed. There's recording fees that you have to pay. and I think that's it, right? And it has to be done within 150 days of that order. There didn't used to be any time limit, so we kind of concocted that between ourselves, because what was problematic was if the tax sale purchaser wouldn't do that, and July 1st comes, what are we going to do with this property? Are we going to just let it hang out, wait for this tax sale purchaser to do what they're supposed to do? No. We arbitrarily, Lisa and I said, there's 30 days, if they don't do it, we're going to avoid the tax sale, you're going to lose your money, we're going to put it up for sale again. Now, then the statute came, I think at first was 60, then we changed it to 60 days because people complained. Now, the statute jumped on Lisa and I and these ladies said, no, you got 150 days. So when you get that order of sale, I send it to my client, my tax sale purchaser, say, hey, do all this stuff, and the order for sale will say on it, you have 150 days. That's a very important thing. And I'm sorry, I didn't mean to
No, good point.
step on your toes, man.
No, very good.
We should have included you in the panel.
No.
That was our mistake.
I'd much rather be over here.
In any case, questions, please, anybody? Yes, David.
I just want to point out, I'm doing one for a client this year, and when I called the auditor's office and spoke to the people that Mitch mentioned, they got me everything I needed within 10 minutes. It's not as daunting.
No, we got great people working at the county in these areas now, I mean, they are unappreciated, but they're real experts in their area, so, thanks for that. So, David had great experience. Mr. Scheidegger?
Yes, if the tax sale purchaser does not have the right to possession, does he have any obligations to secure the property, to comply with code enforcement, otherwise they can say, to prevent damage to the property while he has.
It's an inchoate, it's an inchoate right that you have. I mean, you at this point, you have something more than the average person, but you really don't have anything that would allow you to even take possession or take control of the property. So it really, all that falls on the present owner.
Well,
And what do you think?
there's some,
Can you petition
I
or
don't
do
know if
something
there's
else?
I don't know if it's a statute or a case, but I think the tax sale purchaser, if there is I don't think you can go and do something to a property, a building. You can't go in the building, you can't take possession, you can't, board it up because of getting vandalized, people say. But then I think there's either a case law or a statute that talks about some kind of minimal right that a purchaser can do to try to protect its interest. The best thing to do, what I tell my people is, don't go on the property, don't expend money. If there's a code situation, I tell them to call, I don't tell them to call Tom, I tell them to call the code department.
1 minute.
And you may want to talk to code about it. But really, the very, very, very limited right.
I think you can put up some notices and tell people to get out of there, but how effective that is. Stephen?
Mitch is correct. It's a statute. It's a broad statute that allows anybody to go onto a property in order to maintain it, mow the grass, fix a window, not go in the property. He's absolutely correct about that. But it was revised to specifically include tax sale purchasers.
Yeah, but you can do that. But if it's redeemed, your efforts.
You're out of luck.
You can do that to try to protect your interest. But if somebody comes and redeems it, thanks a lot. See you later.
All right, we have we don't have time for one more question, but we'll take one anyways. Okay, I guess that's it. Time up. Thank you all. Nothing better than talking about tax after lunch.
Is everybody awake still?
We have handouts for anybody that wants them. Run to the back and hand them out.
Great.